Let me begin by saying that I view myself as being completely in favor of the proposition as stated, that judges should be agents in interpreting, honest agent of the enacting legislature. Now, in saying this, I first want to make a distinction between interpretation and construction. Construction is something else, and whether there ought to be construction or not is a very difficult problem. Historically, in our system, judges have had the power to construe, whether they should or not, and whether they should only do it when it is delegated to them by the legislature. And by the way, in my book, I never said that judges should do these things unless the legislature delegated it to them, is another question. But let's look at some situations where historically construction has been there. Construe statutes to avoid constitutional questions. That's something we have done historically forever, to avoid a constitution. That's not interpretation. That's not looking to what the legislature, it's dishonest to call that kind of construction interpretation, and yet it has been done. To require a second look. Throughout the 19th century, statutes were read literally to avoid, statutes in derogation of the common law were read literally. That wasn't interpretation. It was mangling statutes so that legislatures wouldn't make radical changes. It stopped happening at the end of the 19th century because Roscoe Pound and the left noticed that this was being used by judges, who by nature are conservative, to stay with things as they were. Was it good or not? I don't know, but it was true throughout the 19th century. To update, that's much more problematical, to update obsolescent statutes. But there is another way, and one that should interest you, and especially you as a Bork clerk. Bob Bork, influenced by Bickel, in his great work on antitrust, first said, if you read the antitrust laws according to what the enacting legislatures wanted, they would want to protect both competition and competitors. Wow. But to protect competitors would cause courts to do something that courts ought not to do. Therefore, I will construe these statutes to allow only protecting competition. And from then, the whole great work on antitrust that he did. Is that a good idea or a bad idea? I'm not sure. But it is worth thinking about whether you want judges construing and honestly saying that they are construing in some situations, and whether you think that legislators give them that power. Now, Brother Easterbrook says it's insane to give this kind of power to people you can't turn out of office. Maybe insane, but it happened at the very beginning of our country in every single state. What do I mean? Judges have the power to construe the common law. Everybody knows that. The common law is different. They do that. Where did they get that power? The common law of England didn't just come over. When we declared independence, there was no common law of the United States. Every one of the states, some by legislatures, some in their constitution, like New York, delegated to the courts the power to update the common law of England according to common law methods. In other words, the whole of the common law in the United States is statutory. It is statutory, enacted by statute with delegated power to courts to construe it, to update it, to do all the things that all of you in your first term torts classes and contract classes learned that courts, unelected ones, except that they're mainly elected in the states, of course, but are given the power to do within the common law method. Now, again, does that mean that courts can do it as to statutes where they haven't been delegated that power? No. But I'm just saying that it is not insane, nor is it unconstitutional to think about whether, in some circumstances, that should be. Okay, let's shift from construction, which may be allowed or may not be allowed, but which is not to be excluded without thought, to interpretation. Interpretation, in my view, is always backward-looking. Interpretation is you are honest agents, you are interpreting of the enacting legislature. The question is, what does that mean? You try to find what the legislators intended, and that is impossible. Just to say it points out the difficulty of it, because there are any number of different things and things that they said and didn't say and so on, no one meaning and so on. So then the question is, what does it mean to be honest agents? You start with language, but language is itself meaningless outside of context. Text outside of context, and you don't need Wittgenstein to tell you, doesn't mean anything much. Now, okay, let's stop. There are people like the Crits and people like Dick Posner, who's simply a crit of the right, who say that courts can do anything they want. Language doesn't tell you anything. That's nonsense. Language is very important, limits a great deal. On the other hand, to say either language doesn't mean anything or it tells you exactly what it means is both wrong. It's somewhere in between. Text means something in context. I once convinced a judge in a tax case, she happened to be a great bridge player, and she also happens to play touch football, that the phrase, "you should have passed, dummy," means something rather different at the bridge table than at halftime in the Super Bowl game. I mean, you have to read something in the context in which it was enacted. So that language is helpful, but language is also misleading because it changes its meaning. The word substance, something is of substance, meant originally that which lay beneath, substantia. It meant spirit. It came to mean that which is important, because spirit was important. As we became more materialistic, it came to mean matter, that which matter. Today, substance means the opposite of what it meant some time ago. What do you do with language which changes its meaning? Okay, so text first, then context. Legislative history? Of course we all know that legislative history can be fraudulent. That's one of the many helpful things that Nino Scalia has taught us. But that doesn't mean it's useless. That doesn't mean that in looking, if you want to find out what that legislature really intended, what do you look to? I mean, I'm immensely skeptical of legislative history. I'm also immensely skeptical of some words that get thrown in. I start with words, I look at context, and try to see what the words were designed to mean. And this, by the way, has been so from the very beginning. Pufendorf gave an example that Blackstone picked up and which has gotten cited. In Bologna, context, there was brawling, duels. Bologna passes a statute which says, "You shall not shed blood on the streets," punishable by hanging, drawing, and quartering, or other such things. Easterbrook walks down the street, collapses. The good doctor Giovanni Manning comes by, and according to proper medical practice of the time, bleeds him. There is blood in the street. Meyer, the cop, arrests him and says, text. Here, the courts of Bologna, as cited by Buffendorf, picked up by Blackstone, influencing our framers, said, that's nonsense. That's not what this means. It wasn't the mischief, English word, commonly used in England in the 18th and 19th century, the statute was addressed